Minister Shan.
Thank you, sir. Mr. Singh, recommendation 12 opens with the government should have the powers to swiftly disrupt the spread and influence of online falsehoods. The government. The government should have the powers. And the objectives should be achieved as follows. Provide access to, limit or block exposure, disrupt the digital amplification, discredit the sources. And that it goes to set out these capabilities should be able to apply to all relevant platforms. And it goes on to say legislation will be needed to achieve the above objectives. Such legislation should have the following objectives. Measures will need to achieve the objective of breaking virality by being effective in a matter of hours. On the face of it, the recommendation is that the government should have these powers. Second, the opening words cannot be any clearer. The government should have the powers. Second, equally importantly, let's not argue with qualitative words. Courts can move fast. It will, no reason why they cannot move fast and so on. Let's stick to the clear recommendation, matter of hours. You are a lawyer. I've been in practice. Do you think in every case that is necessary, the court can decide in a matter of hours? You know the process. It will have to be filed. It will have to be served. The defendant may wish to come to court and say, I want to argue this, which means due process. How long do you think it will take to get a duty judge? I'm sure you have tried. I don't know whether you have tried, but over 22 years I have tried several times. It can take 2 days. If the duty judge is in a hearing, it can take up to end of the day. This select committee would have been mindful of all of that. It is not possible for you or for me or for anyone else in this House honestly to say the courts can do this in a matter of hours. That's just plain wrong. It's not possible. So let's stick to the select committee recommendations. In a matter of hours, 4 hours, 5 hours, what if it's a weekend? You know how long it takes to get a duty judge? When are you going to get a duty judge? When courts reopen. Sometimes you can go to his house and see him. But, matter of hours, what if he is engaged in something else? He can only give you the time that he can. And it's possible that the defendant will turn up. You can't say all the time it should be ex parte. You've got to give, even in ex parte, there is such thing as contested ex parte. If it's a responsible or respectable party, like a platform, you could say, platform turns up and says, no, we want to argue this case. Due process means you must allow them to argue. That means you must set a hearing date. How long do you think that will take? So, POHA, the process is as follows. We have set up dedicated courts, but we have not pretended that at POHA it can come within a matter of hours. It may not be possible. But private interests in general, we think they can go and try, but it might take, we hope that it can be done in 2 days in sufficiently suitable cases, hopefully a day sometimes, but there will be other times when the judge is not available. That is why this recommendation 12, which is a critical recommendation, says the government should have the powers to swiftly disrupt the spread and influence of online falsehoods. And it says it should be done in a way to achieve the objective of breaking virality by being effective in a matter of hours. If anyone in this House says that a court, you guarantee that a court will decide every single time within a matter of hours when you need it, you're not telling the truth. And I will say so by looking you in the eye. The courts will tell you that's not possible. So let's not use words like courts can decide quickly. Of course they can decide quickly. But as I said to the NMPs yesterday, what does that mean? These are qualitative words. We are talking about hours. I've given concrete examples where things happen within a matter of hours. Private interest, you cannot have any other way other than going to court. We set up a dedicated set of courts for the state courts. We ask them to set up a separate tribunal, but that doesn't mean that order can be obtained within a matter of hours. We can do the same thing in the High Court, but that doesn't mean a court order can be obtained within a matter of hours. You just think in terms of the process. There might be times when there is no defendant, and you can try and get an ex parte, sometimes over the phone, but often there's a platform where these things are carried, and the platform might want to be heard. Facebook or Google or somebody else. So I think the Workers' Party should try and clarify without using subjective terms and bringing in POHA, which is quite different. POFMA, this bill, together with the Select Committee recommendations, are you walking back on it? Are you saying you no longer stand by it? And if you stand by it, how does your current position make any sense? Because you accept there is a serious problem. You accept that something has to be done. Government must have these powers. It must be broken within a matter of hours. The only difference that I see between you and us is now who makes that initial call. And your method doesn't gel with what the recommendation says. So maybe I can hear from you. Thank you.
Mr. Singh.
Thank you, Mr. Speaker. I think a number of points made by Minister. I think first has to do with my position on the committee and the recommendations per se. I don't think it's an attempt to try and wiggle around the words. The government should act swiftly. Legislation should be given, should be provided to the government, and I think POFMA is the legislation that the government has put forward. I think the issue is really response time. I think that's the key pivot that the government and the Workers' Party have.
And that it says the government should have the powers to swiftly disrupt, and says this is the way it should be done.
The Select Committee report, we went through several revisions of it. I was part of a team that looked at recommendation 12 closely. I do not want to share what the deliberations of that small group were because those are confidential, and I don't intend to abuse my parliamentary privilege for that purpose, but I have those emails. I don't intend to read from them. But very clearly, my decision to remove the executive was made quite clear as the decision maker in the original draft. And I think that's the point. The point is, I believe the Select Committee had to put forth an approach to deal with how we're going to deal with the problem. But as to the specific modality, I think that was something for Parliament to decide. So that's dealing with the Select Committee's phraseology and how the issue was put out. Let me deal with the second set of issues that Minister spoke about, which was about speed. Certainly, there appears to be two regimes when the government needs to apply for an interim order, to move quickly against either an individual or a company. In this case, let's say a tech company like Facebook. And yes, I would agree that if it came to a tech company, I would expect them to challenge what the government wants to do. But in that sort of situation, the fact is, POFMA gives advantage to the government. The prima facie case is something that the judge can rule upon as a matter of course. That means the order is given, but as to the arguments that have to be dealt with later, these can be dealt with accordingly. Let me just read from the Act. I'll give an example. If the Minister could just bear with me. Targeted correction order is issued to, this is section 21, or clause 21, I should say, part 4, is issued to the internet intermediary that provided the internet intermediary service by means of which the subject material has been or is being communicated in Singapore, requiring it to communicate by means of that service to all end users in Singapore. And then it goes on to say a statement, a specified statement, and so forth. Now, we look at the identical option under POHA for an individual or company. There is a requisite standard, which is the prima facie standard. Once that standard is met, let's say by a duty judge, the question of hearing the arguments can be dealt with later. And I think this is the point which suggests to me that there is some scope for the courts to deal with the urgent issue that the government wants to resolve, at least in the interim. And then when it comes to the proper hearing, the government can make its case in full and the aggrieved party will have a time to respond.
Mr. Singh, that doesn't quite answer the question. On recommendation 12 and whether executive is mentioned or not, I think we stick to the wordings here because I'm also aware of those emails. And I think it's quite clear what recommendation 12 says, but I don't want to put you in any sort of embarrassment on that. Let's just deal with the hours point. I think it's unarguable, prima facie or whatever, the starting point is for you to file and get attendance before a duty judge. You would accept that that's not always possible a matter of hours. And that's the first point I make. Second point I make is this. If you serve it, as sometimes you will have to, particularly if, say, you decide to make the platform the defendant, and they turn up, and they say, no, before you make a prima facie order, we want to make an argument. We want to be heard. What happens? The court, are you sure, will each time make a decision within a matter of hours, assuming you can even get the judge. If the judge is in a hearing for the whole day, you get to see him at the end of the day, if he wants to see you, if he is able to see you. I think it's a simple point, Mr. Singh. It's unarguable, isn't it, that there will be times that you cannot guarantee that if you go down this route, you will always get it within a matter of hours, prima facie or otherwise. That is the only point. I mean, if you're good enough to accept that, I think we can move on.
First point, Minister, it's no question of an embarrassment for me. I think I'm quite clear as to what I think is the appropriate position taken by the Select Committee report. Decision-making was not explicitly stated which would be the entity, and I think I want to leave it at that. Second point, I think it's an important one Minister makes about, first question was in a matter of hours. And I think the Minister makes a fair point in the case of a duty judge. I mean, if indeed there's only one person, then really it comes to a question of should that be increased? Should we have more duty judges? Again, it's an arguable point. Minister may say, look, it's going to be quite difficult to execute in practice. I happen to think that, again, depending on how urgent the problem is, how bad the situation is, that can be dealt with. The second point about service, it's an important point because it deals with issues of natural justice. It's an important point. Again, we look at POHA and interim orders, for example. Clause 16 says, an interim order takes effect in respect of the respondent, and this is individual or company, when the order is served on the respondent in such a manner as may be prescribed. But critically, B says, when the court dispenses with the service of the order, let me say that again, where the court dispenses with the service of the order, when the service of the order on the respondent is dispensed with by the court, or at such a later time as the court may specify. Again, it suggests to me that the regime can be dealt with to deal with the problem of that falsehood, provided that prima facie threshold is met. Serious problem, serious falsehood put out there, and the court may decide, look, I think service is of a second order right now. We need to deal with this problem, but parties will have to come back before me.
Yes, Mr. Singh, I think let's try and get clearly. The first point is not just a question of resources. Judges have cases. It's not as if there's one judge sitting there doing nothing else but waiting for the government to come in and apply. There's a duty judge regularly to hear urgent cases. Week after week, the duty judge changes. Sometimes it carries on. And as I told you, there can be weekends, there can be public holidays, there can be other issues. The simple point is, neither you nor I nor anyone else can guarantee that it can be gotten in a matter of hours. I assumed you had practiced in this area, but if you hadn't, I'll make that point to you. Second, in terms of service, if it is a known platform and there is an identifiable defendant who is not a rogue party, when you go to the court and the court says, why haven't you served on this party? Why aren't they before the court? What do you say? Okay, let's say we make provisions in urgent matters, we can come and get an interim order in the first place, even before service. Assuming we provide for that. Then what really happens is each time you just go and get an ex parte order. All that the judge has is what you are giving him, and he confirms that you should get the order. Now, even then, after you get the order, you're going to break the virality within a matter of hours, as opposed to an immediate order by the minister. I think you have an insuperable problem there because of the availability of the judges. And if your point is each time the government wishes, it goes ex parte because it's urgent, then how is the court substantial check, other than the fact that the government puts an affidavit, explains it, and says, I think it's urgent, and the court gives it. But my fundamental point is, are you sure it's done in a matter of hours? Are you standing here as a party and guaranteeing that every time it happens, it will be done within a matter of hours? If you say that, we'll just leave it at that, if that's your position.
Thank you for that, Minister. I think it requires a caveat, of course. A caveat is important, and that caveat is there has to be capacity for a duty judge to be available at that time. That's the caveat.
Okay, let's move on. Mr. Leon Perera.
I'd like to pose a clarification to the Law Minister. Is that? Sorry. I had intended originally to pose the clarification to Mr. Cedric Foo, but I think in light of the Law Minister's comments on this point, I'll just pose some clarification to him. And it is quite simple. Is it the position of the Law Minister and the government that our courts could not be sufficiently resourced, structured, if necessary a new process, a new expedited process created, if necessary a new process for assigning judges created, additional capacity created? Is it impossible, is it inconceivable that this could be done in the future in order to issue interim, prima facie decisions in urgent, time-sensitive cases under POFMA? Is that impossible? By definition. By definition, is that impossible in the future if we take all these steps to put in the resources, to put in the process, if necessary, create a special class of judge and so on and so forth? Is that impossible by definition? And I would add that, in other jurisdictions, to the best of my knowledge, I may stand corrected, in other jurisdictions, for example, in some states in the US, it is my understanding that an arrest warrant needs to be approved by a judge under certain circumstances. And these arrest warrants are very time sensitive. And a judge has to make a decision on the balance of probabilities whether to arrest a person, and that's a serious matter, whether to arrest a person in extremely time-sensitive circumstances. Sometimes late at night, the law enforcers will go and see a judge, because that system has been created and structured and resourced in such a way that that is possible. So that's my clarification. Thank you.
Number of points here. Now, the first of which is this. You must go and find, let's take the sequence, the process of these things. First, you've got to draft something and file in court. Okay? We are now talking about the Select Committee's recommendation to do something within a matter of hours. You've got to draft and file. You've got to put aside some time for that. After that, you must find a judge. Let's say in your scenario, we have a High Court judge who does nothing but sits there 24/7, because it can break out any time, and will be available as soon as the government calls. It's technically not impossible. Of course, you can have a judge do nothing but this and no other cases. Or any time, because if he's hearing a case, he can't break the case and come and listen to you. He's got to finish the case for the sitting either until lunchtime or until the evening, depending on the scenario. Duty judges hear their cases too. So we are saying, if supposing something has happened and I want to stop the communication within the next 2 hours, do you think it's possible by going to court? Now, then there are further factors which add further levels of uncertainty. You file, you go before a judge, and you say, look, judge, it is so urgent that I'm not going to serve this on Google or Facebook or wherever it is spreading. I just need an urgent order, ex parte, and then later on I will serve. Sometimes the judge may agree, but the judge may also disagree. Supposing he disagrees, then it takes a further length of time. The decision maker, the person who has the facts, might take one view, and the responsibility for dealing with that situation also rests with the executive. I mean, you know of instances where within 24 hours there have been riots and people have been killed. Supposing the judge says, I think I would like to hear the other side, urgent as it is. It's happened. Urgent inter partes, urgent ex parte applications have been heard on a contested basis. Any of these are possible. The judge could give you ex parte, but he could also ask for contested ex parte. He could ask the other side to turn up quickly. And if he does that, and the other side turns up, and then they say, we don't have time to file an affidavit, but we want to know the basic facts before we can argue. We need until this evening. We need until tomorrow morning. Once you set up a court process, then you must allow for the due process. So my point to you, Mr. Perera, is, having now heard this explanation, is it your position that definitionally it is possible every single time, whenever we want it to be dealt with urgently, that it can be dealt with urgently in a matter of hours? Is that your position?
Mr. Perera.
Thank the Law Minister for his explanation. And I think that there are a number of points that he made which relate to judicial capacity, for want of a better term, and process. Capacity, I think, I would imagine that based on what the Law Minister has said, he can envisage that necessary capacity can be created to deal with such a caseload based on what the Law Minister
waits for the application. That's what I said.
Yes, so I'll take it that necessary capacity can be created. We can create a special class of courts, duty judges. Capacity is a question of resource planning. So sufficient resources are applied, the necessary capacity can be created. Next, there's the issue of process. And I think the Law Minister alluded to the fact that, well, the government will have to word a submission, even an ex parte submission to the court, and that is time-consuming, and while this is going on, the clock is ticking away and the falsehood is viralizing, and so on. Well, within the ministry or the stat board or agency, the civil servants also have to word a submission to the minister or communicate with the minister. Can we not create a process whereby the communication, the form and the format of communication between the civil servant and the minister is very similar to the form and format of communication between the government and the court in those very time-sensitive cases to obtain an initial prima facie decision? So my point there is that I think at the level of process, these things, a process can be created to minimize the time lag from ministry to court. I would put it to the minister that a process can be created in that way. And I think if we address the issues of capacity and the issues of process, I mean, the minister has been talking about the current situation right now with the capacity we have and the process we have. If we can add more resources and capacity and we change the process to make it expedited to arrive at that prima facie decision to stop the viralization, I would put it to the law minister that is perfectly conceivable. And I just want to address the other point that the minister made, that in some cases the judge will not agree. That is precisely the point. In some cases the judge will not agree if the judge feels that he's being asked to make a prima facie decision, but he's looking at it on the balance of probabilities and he feels that the executive is overreaching or the executive is abusing their power. So he may not agree in that case, and that is precisely the value of the check.
I would ask of Mr. Perera not to put words in my mouth. When I said not agreed, it may be because he says, I want to hear what the other side has got to say. So my point to Mr. Perera is, therefore, can I take it, and it'll be very simple, can I take it your position is that definitionally, every single time it is necessary to make a decision, you believe that the courts can be used to make a decision to break the virality within a matter of hours, every single time, when it's necessary to do so. Is that your party's position? Is that your position? If it is yes, yes. If it is no, no. That's all. It will be very good to clarify that.
Courts are sufficiently structured and resourced and the process is defined to enable that to happen, then the answer is yes.
You believe that that can be done by simply putting some submission to the court. Is that it? Whatever the civil servant submit to the minister can simply be submitted to the court.
The Honourable Minister, that a simplified process can be created to absolutely minimize the lead time between minister to court to get a decision. I mean, there is a certain amount of lead time in any case for the internal conversation between civil servants and ministers in such cases. So what we're talking about is the additional lead time between the minister and the court to get that decision to break the virality. So I would put it to the minister that a process can be defined that is very simplified to minimize that lead time. Yes.
I've got the clarification I've needed, sir. Thank you.
Mr. Shah, thank you.